like this one is almost every day. Sometimes I'm having to choose among 2 or 3. In previous years, we were lucky to get 2 or 3 an entire campaign season. The level of interest in the elections has increased enormously. And it's a great opportunity to begin to turn things around in this country. But it's only the first few steps. Now, some of you may not know what a libertarian is. Let me just say a few words on that. After speaking to some Tea Party groups where most of the people were Republican-leaning, I remember a week or so ago, one of them said to the other, you know, Libertarian Party is what we wish the Republican Party were. And another one says, well, Libertarian candidates are the ones we wish the Republican Party would nominate. Now, what is the story behind that? The story behind it is that even if reformers take control of all the party offices in any of the major parties, they cannot necessarily decide who the nominees are going to be if there is a primary system. Because any well-funded candidate can swoop in, spend a bunch of money, delivering his probably only name recognition to enough of the primary voters, and he may take the nomination over the objections of the party leadership. So one of the things you have to watch out for, the primary system was billed as a reform when it was introduced. And like a lot of reforms, it had an effect quite different than what its proponents thought it would have. And one of the things that you need to be concerned about as reformers, because you are reformers, is that it is not enough to demand reform of others. To demand something of another is not to demand something from him, it's to demand what he's going to do to you. If you don't specify the exact details of the reform you want.
That's right.
If you go to court and win a case before a judge or jury, probably not a jury, but in the case that I'm speaking of, and it comes time for the judge to sign the order, if you haven't drafted the order for him to sign, he's liable to turn to your opponent and ask him to write the order. So chances are he's not going to want to do it himself. You have to actually write the language of the reforms you want. You cannot leave those details to the people you demand things of. But you probably are not going to get what you want. Now, if you don't have the skills to write these things yourself, then you'd better identify someone who does and get him on the job and get behind what he does. You at least need to know enough to recognize when it's written right. It's just like hiring a lawyer or a physician or an accountant or anybody else. You need to know enough about his profession, his skills, in order to make sure that he's doing the right job for you.
Right.
If you don't know something about medicine, how are you going to know that the doctor's not a quack?
That's right.
If you don't know enough about law, how do you know your lawyer isn't selling you out to the opposing side? One did that to me. The way I learned the law is the hard way. I had a lawyer betray me. Cost me $2 million.
Oh, dear.
Wow.
I had to sue him for malpractice. I couldn't get any lawyer in Bear County to take the case because they said if they did, they would never win another case.
That's right. I'm sure.
They said, you'll have to get a lawyer from out of town. Well, I couldn't afford to get a lawyer from out of town. So I had to pursue the case pro se. I had to teach myself enough law to conduct a malpractice case.
My goodness.
And guess what?
You won.
They capitulated.
Yep.
They asked my usual lawyer to take the case just so they could surrender to a lawyer instead of to a layman.
My goodness.
But that took a lot of work. I had to really hit the law books. I had to get equivalent of 2 or 3 years of legal education in about 2 or 3 months.
Wow.
It was all I was doing. The skills that are needed to solve our nation's problems are not trivial. I've spent 50 years studying the Constitution. I'm best known as the founder and president of the Constitution Society,
My goodness.
with website at constitution.org. I'm still learning things about it. And when I get into discussions with lawyers who are supposedly experts on this in the field, I'm constantly catching them in errors. You heard earlier about catching teachers in errors. Well, I get to catch lawyers and judges in errors.
Oh, yeah.
Dude, it happens every day. We are led by people who only marginally know what they're doing, if at all. And there are whole fields where people are just winging it. We're seeing that now in the financial field. We see that in the mortgage mess. I've been warning for 14 years that we had to insist on the old court rule of the best evidence rule. You cannot foreclose or may not foreclose unless the mortgagor presents the original of the note. The original with the signature of the debtor. Not a photocopy, not an affidavit that he is the owner and holder of it, the original. And if they had insisted on that, we would not be in the mess we're in today.
Yeah.
But people didn't know. They thought, well, it's okay to accept an affidavit. After all, they're a lending institution. They're, supposedly trustworthy people. No, they're not. You can't trust anybody. You may have to, but you shouldn't.
Right.
So, my campaign website is at jonroland.org, JONROLND.org. There's a lot of stuff there. Even though it's close to the election, I urge all of you to visit and to tell your friends to visit. There probably isn't time for constitution.org before the election. But I ask you to do that because this is an ongoing process. You all need to become educators. I spent some time reviewing textbooks for the State Board of Education, as a result of which several of the key civics textbooks were completely rewritten. I found one
Civics.
American government textbook that since 1950 has been teaching students that an informal amendment is just as good as a formal one. In other words, precedents are a perfectly good way to amend the Constitution. Well, no, they're not. The judges take an oath to preserve, protect, and defend the Constitution, not precedent. especially wrong precedent. And there have been hundreds of wrong precedents. I detail them on my website, showing how incrementally, from precedent to precedent, it's taken us down the rabbit hole we're in today. And there's probably no way to back out of that without amending the Constitution. Not to change it for what it originally meant, but just to get it back to what it meant when it was started.
Excuse me, John. John,
Yeah.
we are going to have, because of time constraints, we're going to have to move into the question and answer session, if that's
Okay.
all right.
All right?
Do we have any questions for Mr. Roland at this moment? I just have one while you're up there. I would like to know, if you are elected Attorney General of the state of Texas, will you take the lead? Will you take the bull by the horns and coerce or do whatever is necessary to get the other attorneys general of this country to repeal Obamacare on whatever grounds we possibly can find?
Yeah.
Yes.
Well, that's an interesting situation because my incumbent opponent signed on to an existing lawsuit prepared by a friend of mine, David Rifkin, who's a pretty good lawyer, but he wrote the lawsuit while the bill was still in Congress and before it had been adopted. And by the time it was adopted, changes were introduced that largely shot down most of the litigation, most of the arguments used in it. And I've been advising, trying to, Rifkin and others, you have really got to rewrite these pleadings and argue on a different theory, or you're going to be shot down on almost everything. Well, the lawsuit has survived. Well, all but two of the key arguments or demands were struck down, and it's likely at least one of the other will be too. So if you don't argue these things properly, you're going to lose. You have to know what you're doing. And by the way, the thing that the Congress did to cut the legs out from under the lawsuit was they introduced clauses whereby the IRS may not either lien or levy in order to collect the insurance premiums. And the whole premise of the lawsuit was to forbid the levying and liening of, to collect the insurance premiums. Well, if you don't have that angle, what can the IRS do? Well, what they still can do is using, withholding, collect the money, and then refuse to give it back to you. And done you not for the insurance premium, but for other taxes.
Okay, thank you. John, you seem to have wandered a bit off point. I still didn't quite get my answer. Would you take the lead? Would you put Texas in the lead and tell the other attorneys general to do whatever it takes to repeal Obamacare, yes or no?
Well, of course, if I redrafted the pleadings and the others signed on to it, that would be taking the lead. So that was an attempt to answer your question.
Thank you.
Right.
Thank you, John. We're running a little bit late, so we're going to let John go back to the candidates table. He will continue to take questions if anybody who's interested. I'd like to bring on our next speaker, and I made a point to make sure I knew how to pronounce his last name because I read it phonetically.